Yeah, thank you so much for the opportunity that have been accorded. We'll be talking about what they call the Ubuntu Jurimetric Manifesto and consider it a public defense of the Luogo Ubuntu Constitutionalism Index, abbreviated as LUCI, LUCI, and the Ubuntu Legal Index, abbreviated as ULI. Now, I'm assuming, particularly in light of this discussion, that I'll be making an address before the Global Academy of Law and Philosophy and Comparative Constitutionalism. And so some of the works that I've come up with in almost my 10-year span in lieu of the Doctorate of Law, particularly on Ubuntu and the law, towards a new constitutional dispensation. And in my discoveries, in my analysis, I'm proud to have come up with substantive discussions, but particularly inventions that are pertinent for the School of Law, but also for the world. So I consider this as a letter to the world, most skeptical minds, and I say that with intention. So to the distinguished professors of, say, Oxford or Harvard, the Sorbonne and the Makerere, to the justices of constitutional courts across Africa and beyond, to the doctoral candidates whom we will inherit the jurisprudence we will build today, to the policymakers, to law reformers and advocates who demand that law serve justice, not merely the process. I am happy to be able to make these discussions with you, and I'm also proud to note that you are the most difficult audience in the world. You have seen every argument before, you have read every theory, you have sat through hundreds of defenses, thousands of lectures, millions of pages of scholarship, and you are not easily impressed, you are not easily moved, you are not easily convinced. So I come mindful of those concepts that are just presented. Interestingly, ladies and gentlemen, I do not come to impress you. I actually come to challenge you. I come to tell you that for the 30 years that have passed in the field of Africa, especially as far as constitutional jurisprudence has been engaged, particularly in a collective act of intellectual evasion, we have invoked Ubuntu as a noble sentiment while failing to build the instruments that would make it a justiciable standard. We have raised judges for mentioning Ubuntu while ignoring whether their reasoning actually does change because of it. Anyhow, we have produced thousands of articles celebrating Ubuntu's potential while producing zero frameworks for measuring its presence. That evasion ends today, and that is what I'm about to present before us today. Ladies and gentlemen, I have built the instruments, I have tested them, I am ready to defend them before the most demanding tribunal in the world, and that is you. And so I am mindful that I have a heavy task on my end to be able to convince you in light of this discussion. Let us begin. I will argue my discussion in terms of parts. Part one is the problem. Why 30 years of Ubuntu's jurisprudence has actually failed to deliver. Why does this become substantial today. You will recall, particularly in 1995, the Southern African Constitutional Court did something unprecedented. It struck down the death penalty, not primarily on Western dignity grounds, not on comparative constitutional precedents, but on the basis of an indigenous African philosophy called Ubuntu. The judgment was magnificent. It was cited around the world. It announced that African jurisprudence had something original to contribute to global constitutionalism. And that, my friend, is something worth to take note. But then begs the question, that was 30 years ago. Since then, Ubuntu has been cited in hundreds of judgments across South Africa, Kenya, Uganda, Zimbabwe, Tanzania, and beyond. It has been invoked in cases involving the death penalty, housing evictions, customary law, succession, defamation, bail, environmental protection, and even administrative justice. It has been inscribed in constitutional preambles. It has been a subject of thousands of scholarly articles, dozens of doctoral theses, and countless conferences. And yet, ask yourself, what has been the measurable, systematic, cumulative impact of 30 years of Ubuntu jurisprudence? That, my friend, is a question. Not the impact of a single brilliant judgment, not the intuition of a particular judge, but the collective systematic impact of Ubuntu as a constitutional force. The honest answer is we do not know. That is the honest answer. We do not know whether Ubuntu alignment has increased or even decreased over time. We do not know whether the South African Constitutional Court is more Ubuntu aligned than the Kenyan Court of Appeal, for example. We do not know whether Ubuntu reasoning in environmental cases is stronger or weaker than Ubuntu reasoning in criminal cases. We do not know whether judicial training programs have improved Ubuntu alignment. We do not know whether Ubuntu citations actually correlate with Ubuntu outcomes. That, my friends, is a problem. Listen, we do not know any of it because we have never built the instrument to find out. This is not a failure of judicial competence. It is a failure of scholarly imagination. We have remained content to analyze Ubuntu case by case, judgment by judgment, antidote by antidote. We have never asked, what would it take to measure Ubuntu systematically? What would it take to turn Ubuntu from concept that is invoked into a standard that is assessed? This monograph answers this particular question. This discussion specifically is tailored to answer those buzzing questions. Let me go to part 2. Part 2 is what I would call the architecture. This architecture is called the logo framework as a doctrinal foundation. Now, before measurement comes doctrine. Before the index comes the architecture. Let us move slowly. The Lubbock framework for Ubuntu constitutionalism is the doctrinal foundation upon which everything else rests. It comprises 20 original theories, doctrines, principles, and tests. It is organized into 5 jurisprudential clusters, each addressing a distinct moment in the constitutional life cycle. Let me state each doctrine with precision so that we understand the discussion. Cluster 1. Cluster 1 is the diagnosis. In other words, where does the constitutional system fail Ubuntu? In light of Doctrine 1, the Ubuntu deficit doctrine, a constitutional failure to reflect Ubuntu values in legal reasoning or institutional design, constitutes a cognizable legal defect, an Ubuntu deficit, that may be invoked in constitutional review proceedings. Courts must affirmatively identify and remedy Ubuntu deficits in legislation and administrative action. Doctrine number 2, the selective prosecution test. A pattern of selective or even fragmented accountability disproportionately targeting the vulnerable or those already subject to communal censure may be challenged as incompatible with Ubuntu equality principles. Prosecutorial discretion must reflect communal solidarity. Let me now proceed to doctrine number 3. The collective harm principle. Harm to any member of a community diminishes the community as a whole. So constitutional remedies must address not only individual harm, but the communal disruption caused by it. A remedy that restores the individual but leaves the community fractured is not adequate. Very important. Doctrine number 4, the relational responsibility doctrine. Legal responsibility is not merely individual, but relational. Courts must consider the web of relational obligations within which alleged wrongdoers and victims are embedded, and craft responses that address relational breakdown rather than merely attributing individual blame. Very important. Permit me now proceed to cluster 2. Cluster 2 is dubbed remedy. In other words, how should Ubuntu respond to constitutional violation? And here I want to address doctrine number 5. Doctrine number 5 is the irreversibility principle. where a constitutional violation produces irreversible harm, death, for example, serious bodily harm, permanent dispossession, or destruction of communal bonds. In other words, courts must give this irreversibility decisive weight and must prefer remedies that prevent such violations over those that merely compensate. Very important. Doctrine number 6. The restorative imperative doctrine. Constitutional remedies must, wherever possible, be oriented towards the restoration of the right relationship between parties rather than the imposition of punitive or deterrent sanctions. In other words, courts should favor restorative remedies over punitive ones whenever restoration is possible and effective. Very, very important. Let's continue to doctrine number 7. The apology weight principle. In defamation, dignitary harm, and relational wrongs, courts must give substantial weight to apology, acknowledgement of harm, and restorative discourse as constitutional remedies. In other words, monetary damages alone cannot restore relation dignity. Remember that. Doctrine number 8. The healing priority test. And in this, in any proceeding where restoration of communal cohesion is at stake, courts must give priority to remedies with healing potential over remedies that leave communal wounds undressed. Where restoration and punishment conflict, then restoration should prevail unless clearly inadequate. Now, my friends, let me continue with cluster number 3. Cluster number 3 talks about the humane coercion. In other words, how should the state coerce in Ubuntu aligned ways? And in doing this, I will address doctrine number 9. And doctrine number 9 talks about the dignity in detention doctrine. Detention must be administered consistently with Ubuntu dignity principles, including maintenance of family connections, preservation of community ties, and provisions of conditions that affirm rather than negate the detainee's humanity. Very important. Doctrine number 10. Doctrine number 10 is the humane relief principle. All forms of state coercion, things like arrest, detention, eviction, forced removal, must be assessed not only from formal legality, but for humanness. A formally legal act that is inhumane may be constitutionally invalid. Important to note. Doctrine number 11. The family community nexus test. In any proceeding that may result, for example, in the separation of person from family or community, courts must assess the constitutional significance of that separation with reference to Ubuntu values. The family community nexus is a constitutionally significant dimension of human personhood. Very important as well. Doctrine number 12. Proportionality in relations doctrine. Now, the proportionality inquiry must be expanded to include relational costs, not only whether a measure proportionately limits an individual's right, but whether it proportionately disrupts the relational bonds through which constitutional values are lived. Very important as well. Let me now go to cluster number 4. Cluster number 4 is what I call decolonial meaning. Whose language speaks the Constitution is what I'm asking here. And here I'll talk about doctrine number 13, which I call the Ubuntu semiotic principle. Now, constitutional language must be interpreted in a way that reflects African communal meaning. The language imagery and the rhetorical structures through which Ubuntu values are expressed constitute a constitutional discourse that courts must recognize. Doctrine number 14, the indigenous authority doctrine. Under this, African indigenous philosophical traditions constitute authoritative sources of constitutional interpretation, co-equal in principle with received traditions of Western constitutional thought. Very important as well. Let me proceed to doctrine number 15. The living law test. Customary law as a living system of norms continuously generated and refined through community practice constitutes a constitutionally recognized source of law. Courts must engage with customary law in its living form, not merely its codified or even historical forms. Very important as well. Doctrine number 16. The decolonization or the decolonial interpretation principle. Constitutional interpretation must actively resist interpretive moves that reproduce colonial heresies of value. Where colonial and indigenous interpretations do conflict, the indigenous interpretation should prevail unless clearly unconstitutional. Very important as well. Cluster number 5. And in cluster number 5, I'm talking about the measurement and the horizon. In other words, how do we know whether or not we are succeeding? And in this, I talk about doctrine 17, the Ubuntu diagnostic principle. Now, the Ubuntu alignment of a judgment or stature or policy in terms of an instrument can actually or should be assessed through a structured diagnostic methodology. Constitutional systems can be evaluated for their degree of Ubuntu alignment. Yes? In light of doctrine number 18, my argument is in terms of the comparative Ubuntu test. The Ubuntu alignment is properly assessed not only in absolute terms, but comparatively across jurisdiction. Time periods and constitutional domains become important in terms of this assessment. When I proceed to doctrine number 19, the intergenerational stewardship doctrine, the constitutional community includes not only the living, but the past and the future generations. So constitutional reasoning must account for the interests of the future generations as constitutionally significant stakeholders. And that is extremely important as well. Let me proceed to doctrine number 20, In doctrine number 20, I talk about the ecological Ubuntu principle. The relationship between human communities and their natural environment is a relational obligation, not merely a resource allocation question. Environmental degradation is a constitutional wrong not only because it harms present human beings, but because it violates the relationship between communities and their ecological inheritance. So we see the bond, the unity, the oneness, the Ubuntu-ness. So this is the architecture of the 20 doctrines, the five clusters that I talked about. So in terms of a logical progression from diagnosis to restoration of human cohesion to decolonial meaning to measurement and horizon, it is not a collection of proverbs. It is a system. It is a jurisprudence as an architecture. And this, my friend, is important because it is novel in our jurisprudence today. Let me now take us through part 3. And in part 3, I talk about the instruments. We're getting into the instruments now. And in the instruments, I will talk about the LUCI. You remember I abbreviated the LUCI as an umbrella and then the ULI as a blade. Now, a framework without measurement is a library without a catalog. Doctrines without metrics are aspirations without accountability. And that is something we need to think about as well. Therefore, I have built 2 instruments. LUCI, LUCI, is the Lubogo Ubuntu Constitutionalism Index. It is the umbrella. It defines what Ubuntu constitutionalism means across 10 dimensions. Each dimension is derived directly from the Lubogo framework, and each captures a distinct aspect of Ubuntu constitutionalism that cannot be reduced to any other. And that is extremely important as we delve deeper. The 10 dimensions of LUCI are as follows. First, communitarian reasoning, anchored in doctrines 1 to 4. And it asks whether the judgment recognizes social interconnectedness and balances individual rights with collective well-being. Second is restorative logic. Now, this is anchored in doctrines 5 through 8, and it asks whether the judgment emphasizes reconciliation, healing, and restoration of relationships. The third is intergenerational justice. And this is anchored in Doctrine 19 because it asks whether the judgment protects future generations and long-term constitutional integrity. Fourth is dignity beyond individualism. And this is anchored in doctrines number 9 through 12. And it asks whether dignity framed as relational rather than atomistic. And then fifth is indigenous epistemic authority. And this is anchored in doctrines number 13 through 16. It asks whether the judgment recognizes African legal epistemologies as constitutionally authoritative. And then sixth is equality and social inclusion. And this is anchored in doctrines number 2 and 10. And it asks whether the judgment meaningfully addresses social and economic exclusion. And then seventh is decolonial constitutional transformation. And this is anchored in doctrines 16. It asks whether the judgment explicitly departs from colonial legal logic in favor of African normative frameworks. And then we proceed to the eighth. The eighth is procedural fairness and human governance, anchored in doctrines 10 and 12. And this asks whether the judgment ensures fair procedure and human administration. And then we proceed further. When you go to 9, or the ninth is in the context of environmental and ecological stewardship. And this is anchored in doctrines 20. And it asks whether the judgment protects ecological integrity and recognizes communal environmental relationship. Important to understand. So if I go further in 10th basically talks about customary law integration and living law recognition. It's anchored in doctrines 14 and 15, and it asks whether the judgment engages with customary law in its living, evolving form. Very, very important. Now, my friends, ULI, that is ULI, then becomes the Ubuntu legal index. It is the blade. It is the operational scoring instrument that applies LUCI dimensions to actual judgments. So, for each dimension, ULI assesses 4 types of evidence. 4 types of evidence. In other words, the lexical evidence measures the frequency of Ubuntu relevant keywords and phrases. It is the weakest indicator, presence without depth, but it is a necessary starting point. A necessary starting point. Now, when you are talking about the doctrinal evidence, the measurement citation of Ubuntu, principles of the Logo framework doctrines, and the landmark Ubuntu cases, this becomes stronger than the lexical evidence because it now shows explicit engagement with the tradition. Now, when you're talking about semantic evidence, measures reasoning that reflects Ubuntu values even when explicit keywords are absent. This then becomes the strongest indicator of genuine conceptual alignment. In other words, a judgment might never use the word Ubuntu, yet reason in a deeply communitarian, restorative, relational manner. So semantic evidence captures that. When I proceed further in terms of the remedial evidence measures, this measures whether, for example, the remedy aligns with Ubuntu justice. It is a restorative or punitive, relational or individualistic. In others, does it aim to heal or merely to compensate? This is the strongest indicator of outcomes. Reasoning alone is not enough. Ubuntu must produce Ubuntu results. Now, The dimension score, my friends, is the arithmetic means of these four evidence types. In other words, each dimension receives a score from 0 to 100. Remember that. The composite of ULI score is the geometric mean of the dimension scores. I chose the geometric mean for a specific philosophical reason. The arithmetic mean allows compensation. A judgment could score 100 on environmental stewardship and 0 on commentary and reasoning. And the arithmetic mean would be 50, moderate Ubuntu alignment. But such a judgment is not moderately Ubuntu aligned. So it then becomes fundamentally deficient. Ubuntu is holistic. Balance is not optional. The geometric means forbids compensation. So a very low score in any dimension drags the entire composite down. To achieve a high composite score, a judgment must perform well across all dimensions. Very important as well. Now, the composite of ULI as a score is interpreted through 5 aligned bands. 0 to 19 is Ubuntu contrary. In other words, the judgment is incompatible with Ubuntu constitutionalism. The signal is red. The judgment meaning is review. Now, when you talk about 20 to 39, that becomes weak in terms of Ubuntu alignment. Ubuntu is mentioned but does not influence reasoning or outcome. So the signal is orange. The judicial meaning is caution. Remember that. Now, if you're to proceed from, say, 40 to 59, that becomes moderate Ubuntu alignment. Ubuntu influences some aspects, but not the central outcome. The signal then becomes yellow, meaning the judgment is developed. Now, if you're to proceed in terms of 60 to 79, that is a strong Ubuntu alignment. Joining Ubuntu engagements influences the outcome. So the signal becomes blue-green. The judicial meaning is command. Now, if you're to proceed further, in terms of 80, for example, to 100, that becomes Ubuntu exemplar. In other words, Ubuntu reasoning centrally determines the outcome. The judgment could not be understood without reference to Ubuntu. The signal is green, and the judicial meaning is affirm. Please, let's move slowly so we understand this wonderful, novel, interesting discussion. Let me proceed to part 4. And under part 4, part 4 is what I dub the demonstration. I will argue in the context of a popular case, the Mukwanyane, as a scored unknown. We probably all know Mukwanyane case in South Africa. But let me show you the instrument at work on the most celebrated Ubuntu judgment perhaps in African history. So I have applied ULI to S versus Mukwanyane, the 1995 South African Constitutional Court decision that struck down the death penalty. very popular when it comes to the philosophy of Ubuntu. Now, on communitarian reasoning, Mukwanyane scores 75. The court engaged substantially with communal harm, collective responsibility, and social restoration. It repeatedly framed the death penalty as an injury to the community, not merely to the individual concerned. Okay? If I'm to grade it on the concept of restorative logic, it scores 88. Why? The court explicitly emphasized reconciliation and healing as a constitutional value. Look at judgment of Justice Langa's articulation of Ubuntu as a move away from a jurisprudence of retribution towards a jurisprudence of reconciliation became paradigmatic in the context of that. So you cannot take that away. Now, in light of intergenerational justice, it scores 45. There is limited forward-looking orientation. The court focuses primarily on the present harms. This is not a failure. The subject matter did not prominently raise intergenerational issues, but the instrument correctly reports what is present and what is absent. Remember that as well. On dignity, beyond individualism, it scores 82. The court eloquently articulates relational dignity. It insists that even the condemned remain part of human community. And then if you look at it in the concept of on indigenous epistemic authority, it scores 78. Ubuntu is explicitly cited as an indigenous African constitutional value. So the court departs from Western precedents and affirms South African constitutionalism over normative foundations. And that becomes also important. Now, if you're to look at it in the context of equality and social inclusion, it scores, say, 65. The death penalty becomes disproportionate in the concept of the impact on the poor and marginalized. It is identified and also given weight in that context. If you look at it in the context of the decolonial constitutional transformation, it scores, say, 58, because it creates a departure from colonial legal tradition and is noted. So African constitutionalism becomes distinctive and affirmed, but the decolonial framing is implicit rather than explicit in this context. If you look at it in the context of procedural fairness and human governance, for example, it scores about 75. Why? The court provides extensive analysis of the procedural inadequacies of capital proceedings in terms of human administration. It is affirmed as a constitutional value in that context as well. Now, if I'm to analyze that in the context of environmental and maybe ecological stewardship, it scores maybe 12, because there is no engagement with environmental dimensions. So the subject matter did not raise these issues. Yes, the score reflects absence, not deficiency. Please remember that. So if you are to address it also perhaps in the context of customary law, in terms of customary law integration and living law recognition, it scores maybe, say, 55, because Ubuntu is invoked as a living legal value. Its customary roots are acknowledged, but the judgment does not deeply engage with living customary law methodology. that is something as well that is extremely important to note. Now, it is also important to note that the product, yes, the product of these 10 scores is approximately 2.47 times 10 to the 18th power. The geometric mean, the 10th root of that product is 69.1. So Mukwanyane scores 69.1, which becomes a strong Ubuntu alignment in the context of what we have tried to go through and calculate in quotes with you. So, note that the honesty of the instrument, Mukwanyane is a great judgment. It is one of the greatest constitutional in history, but it is not perfect. It is intergenerational. Justice scores is moderate. Its environmental score is absent because the case did not raise it. Its decolonial framing is implicit rather than explicit. Its customary law engagement is partial as well. So one can note that the instrument obviously does not inflate, it actually reports. And a score of 69 is quite strong in terms of an Ubuntu alignment, and is still an extraordinary achievement by any standard. So it places Mukwanyane in the top tier of Ubuntu aligned jurisprudence. But it also tells us where there is room for growth. In other words, it gives subsequent courts a roadmap for building on Mukwanyane's foundation while extending Ubuntu reasoning into domains that the Constitutional Court did not reach in, say, 1995. Please follow with me. This, my friends, then becomes the value of measurement. It does not diminish greatness, it specifies it. It specifies it. It specifies it. So let me now take you to what I call part number 5. Now, under part number 5, I talk about the validation. The validation. The validation. You will realize that evidence that the instrument works will be understood as the validation. So every skeptic demands evidence, and here is the evidence. Yes, here is the evidence. ULI has been validated through a pilot study of 20 landmark constitutional cases from South Africa, from Kenya, from Uganda, from Nigeria, and the African Commission. So a panel of 10 African constitutional law scholars, each holding a doctorate, each with published work on Ubuntu or African constitutionalism, scored each case for Ubuntu alignment. Please bear with me as I proceed deeper. Let me begin with this. The Pearson correlation between ULI or ULI scores and expert score is 0.87. This exceeds the conventional threshold of strong construct validity. So when experts think a judgment is highly Ubuntu aligned, then ULI gives a high score. When experts think it is weakly aligned, then ULI gives a lower score. Okay? 2 independent scores applied the ULI rubric to the same 20 cases. The Cronbach alpha is 0.989. This exceeds the threshold for high internal consistency. The scores agreed with each other. The instrument produces consistent results across different hands, and that is important as well. Let me proceed further in light of the Cohen-Kappa for alignment of band classification. The Cohen-Kappa for alignment band classification is 0.82. This exceeds the threshold of substantial agreement. Scorers reliably placed judgments in the same band. I'm about to conclude in the next 2 to 5 minutes. The same score applied the rubric to the same cases 4 weeks apart. So the retest correlation is 0.93. The instrument produces stable results over time. Now, robustness checks confirm that the results are not artifacts of methodological choices. So using arithmetic mean instead of geometric mean increases composite scores by 4 to 7 points, confirming that the geometric mean is more demanding. So using different weights schemes changes composite scores by only plus or minus 2 points. So removing the lexical indicator decreases score by 1 to 3 points. Lexical evidence adds a modest but real signal. So removing the remedial indicator decreases score, say, by 5 to 8 points, confirming that remedial evidence is crucial or critical. So Ubuntu must produce Ubuntu outcomes. Okay, the instrument, my friend, does work. It is reliable, it is valid, it is robust. It is reliable, it is valid, it is robust. Let me now take us through part 6. And part 6 has to do with the digital future in the context of our discussion, where digital future therefore becomes law as a code. Law as a code. So when I talk about digital future, I am framing law as a code. We are not antiquarians. We are jurimetricians. So in doing so, I created what they call a Python prototype of the ULI scoring engine that has been dubbed version 1.00. And I completed this in June 2026. And the prototype accepts a judgment text, pre-processes it, scores lexical, doctrinal, semantic, and remedial indicators, aggregated into dimension score using arithmetic means. It calculates the composite ULI using the geometric mean, classifies the alignment band, and generates a full report, including a court citable citation in or scholar format. Now, the future digital expansion of this project includes a web-based ULI calculator for public access, an API integration with legal research platforms, advanced machine learnings for automated semantic scoring using transformer-based language models fine-tuned on African legal text corpora, and a Pan-African Ubuntu constitutionalism observatory providing real-time data on Ubuntu alignment across the continent. That, my friend, is extremely important. Now, As I conclude, this is the invitation. What we ask of the world, ladies and gentlemen, scholars, intellectuals, philosophers, I have built the instruments. I have tested them. I am ready to defend them. Now, I invite the world to use them. I invite judges to use LUCI as a structuring framework for Ubuntu reasoning. Rather than invoking Ubuntu in a conclusory way, one should ask, how does this case implicate communitarian reasoning? What would a restorative remedy look like? Does this judgment protect future generations? Is dignity treated relationally? Does the judgment recognize indigenous epistemic authority? Those, my friends, are fundamental questions. Therefore, I invite law reform bodies to use LUCI to evaluate proposed legislation. Does the new law align with Ubuntu constitutionalism? Which dimensions are strong? Which dimensions are weak? I invite constitutional commissions to use LUCI to evaluate the Ubuntu alignment of existing constitutional provisions. Systematic assessment can guide constitutional amendment and even development. My friends, I invite legal scholars to use LUCI to compare Ubuntu alignment across jurisdictions, to track Ubuntu alignment over time, to identify underdevelopment in terms of dimensions, to test hypotheses about the determinants of Ubuntu alignment, and to contribute to empirical comparative constitutional law. That, my friend, is extremely important. I invite, ladies and gentlemen, the Global Academy to test this instrument against their own traditions. Any legal system that wishes to measure its alignment with relational values in terms of communitarian reasoning or restorative justice, in terms of intergenerational equity, relational dignity, ecological stewardship, can actually adapt the LUCI and the ULI framework to its own normative traditions. My friends, this is not an African provincialism. This is global methodological contribution. Forget about African provincialism. Think about methodological contribution. I am aware, as I conclude, finally, that there are substantive limits, just like anything in life would demand. But then the question is, what we do not yet know is definitely a limit. And honesty requires me to answer that. I will be quick to say the current semantic scoring relies on rule-based heuristics. So full transformer-based natural language processing fine-tuned on a large corpus of African legal text. That should be the next phase. It is planned and partially funded, but it's not yet complete. I would argue that manual experts would demand serious resource intensiveness. The web-based calculator will demonstrate accessibility, but that deployment is scheduled for some time, say 2 years from now. So the validation sample of say 20 cases is also robust for a pilot study, but full validation across all say 55 African Union member states is perhaps the horizon. My friends, Ubuntu is not only African normative tradition. Hunlu, Mat, Wujama, and others deserve their own indices. I invite that scholarship. So ULI does not replace judicial reasoning. It is a tool for enhancing rigor and transparency. The judge remains sovereign. The index is only a servant. My friends, some constitutional domains are underdeveloped in Ubuntu jurisprudence. Digital rights, artificial intelligence, governance, cybercrime, data protection. These domains require doctrinal elaboration before full ULI scoring can actually be possible. Those, my friends, create substantive limits. They cannot be evaded. They are the agenda for the next decade of research. My friends, it has been an honor for me to be able to discuss this journey with you. It's a novel journey. No one has ever done it in the world. It's the first of the kind, but it's the beginning. So for over 30 years, African constitutionalism has suffered not a poverty of ideas, but a poverty of instruments. We've had the wisdom of Ubuntu, rich, profound, humane, uniquely suited to the relational challenges of the 21st century. But we have lacked the tools to deploy that wisdom with the rigor that the legal academy demands and that constitutional justice deserves. My friends, the Lubogo framework provides the doctrinal architecture. LUCI, LUCI, provides the constitutional umbrella. ULI, ULI provides the jurimetric blade. Together, they form a complete African constitutional language. Endogenous, rigorous, measurable, citable, and also court deployable. My friends, my central claim stands. Ubuntu can be measured. Measurement does not diminish it. Measured Ubuntu is a powerful Ubuntu capable of commanding the respect of comparative constitutional scholarship, capable of jurimetric analysis, capable of the international legal academy. Ladies and gentlemen, I offer this work not as a final word, but as a first discipline. Ladies and gentlemen, Ubuntu is not a slogan. Ubuntu is a method. And in saying so, LUCI, LUCI, is not a score. It is a standard. And ULI is not just a number. It is a conversation. My friends, the conversation begins now. I so submit. I thank you. Once again, my name is Isaac Christopher Lubogo, and the major discussion has come from my doctoral thesis, Ubuntu and the Law Towards a New Constitutional Dispensation. Consider this Ubuntu Jurimetrics in this June of 2026. I so submit. Thank you very much.